We have a couple of more minutes to go, just waiting some more people to join. And at 11 sharp, I think we can start.
Yeah, we'll start on time.
Requesting all the speakers to kindly open their cameras and mics. Thank you so much. We have more than 50 participants, and there should be more very soon. But since we are already live, I think we can start the webinar at least. So thank you everyone so much for joining today, and a very good morning to everyone. This is the FICCI webinar on DPDP Act and the medtech sector from compliance to implementation. As part of FICCI's continued engagement on the Digital Personal Data Protection Act and its sectoral implications, a series of webinars has been organized to build awareness and support sectoral preparedness across healthcare and medtech. The earlier sessions, which have been two webinars before this, brought together legal experts, healthcare leaders, and industry stakeholders to discuss the evolving data protection framework in India and its implications for the health sector. Mr. Tishampati Singh is our legal expert, and he has provided the legal overview of the Act, its regulatory contours, particularly related to the health sector. And the panelists have further discussed and examined operational and compliance considerations for the healthcare providers and digital health stakeholders. So, building on these discussions, today's session, which is the third webinar, shifts focus to the medtech ecosystem. We have very eminent speakers today again with us. And we start with Dr. Harsh Mahajan, who is the mentor for FICCI Health Sector and founder and chairman of Mahajan Imaging and Labs. We have Mr. Tishampati Sen, Advocate Supreme Court of India. We have Mr. Ram Prasad Raju, Global Privacy Manager, India Cross Sectors, Johnson & Johnson MedTech India. Ms. Sivani Pisapati, Director Cybersecurity, GE Healthcare India, and Ms. Anasuya Mohan Rao, Clinical Partnership Leader, Clinical Science Leader for Philips India. So I welcome you all, and I request Dr. Harsh Mahajan to kindly take the lead and give the opening remarks for today's session. Thank you, sir.
Thank you very much, Shilpa. Good morning. And it's a pleasure for me to extend a warm welcome to all the distinguished speakers and participants. On behalf of the FICCI Health Services and Medical Devices community, it is a privilege to welcome you to this webinar on the DPDP Act and the medtech sector, and what we've called it from compliance to implementation. India's healthcare and medtech ecosystem is rapidly evolving, with devices becoming increasingly connected, mostly software driven and data intensive. From imaging systems and remote monitoring tools to software as a medical device and AI enabled diagnostics, data now plays a central role in how medical technologies are designed and used. And this is only going to grow in the months and years to come. With this transformation, which is happening rapidly, protecting personal and device generated health data and ensuring responsible governance has become essential. The Digital Personal Data Protection Act, or the DPDP Act for short, represents a significant step towards a robust and accountable data governance framework in India. I think an act like this is very necessary, and we want to look at this in a very holistic and constructive manner so that this can be adopted and it can be implemented both in spirit as well as on the ground as it was meant to be. Now, if we talk for the medtech sector, it introduces new compliance responsibilities across the product life cycle, from design and development to deployment and post market use. At the same time, it offers an opportunity to embed privacy by design, strengthen cybersecurity practices, and build ultimately greater trust across the healthcare ecosystem. And if we take this opportunity head on and are able to embed within our medical equipment, software, design systems which can take care of what this act and the rules actually want to achieve, then I don't think we'll have any problem going forward. FICCI, as you know, has been engaging stakeholders through a series of discussions on the DPDP framework, building on earlier sessions that focused on awareness. Today's webinar aims to move the conversation towards practical compliance and implementation for the medtech sector. Of course, there is always going to be overlap between the medtech sector and the services sector, the delivery sector, the diagnostic sector, the MVT sector, even the Ayush sector, if we talk about it, because each and every one will be a repository of patients' personal data. Today, the key areas of discussion will include governance of device generated and patient linked data, cybersecurity and vulnerability management across device life cycles, consent and accountability within clinical workflows. The roles of manufacturers, software developers, and healthcare providers will be discussed in detail. We are privileged to have with us an eminent panel bringing legal, industry, and technical expertise. I'm really confident that today's discussion will provide practical insights to help medtech organizations navigate this evolving regulatory landscape. Thank you all for joining us. I look forward to an engaging discussion. And may I now invite the man of the moment who's been very, very helpful. He's given us so much time. He's studied the Act and the rules in depth along with his large team of juniors. Pleasure now to invite Mr. Tishampati Sen, Advocate, Supreme Court of India, to share his perspectives on the legal implications of the DPDP Act for the medtech and medical devices sector. Mr. Sen brings extensive experience in constitutional and regulatory matters and has been closely involved in analyzing the legal contours of the DPDP framework and its implications across sectors, more so focused on healthcare and medical technology. So over to you, Mr. Sen, to take us through the contours of the Act, the rules, how it impacts the medtech sector, those who, startups, large companies developing software used as a tool, and of course, even this, medical medtech services sector, which has access to some of the data of patients, maybe not the names, maybe not the other details, but to the images, to the the numbers on the lab reports and all of that. So over to you, and we look forward to, and also, as Priya Joshi reminds me, please also share how do we define Make in India under the contours of this act? Is it going to be any different? So over to you, Mr. Sen. Take it up from here.
Thank you so much. And thank you, Dr. Mahajan. It's always wonderful hearing about myself from you. You always make it seem so much better than what it is. But thank you so much. And thank you so much to Shilpa as well for the introduction. And really to Fiki for organizing this and really taking the pains to do a series on a new law, which will have an impact on all of our lives and in every business. I think one of the things that Dr. Mahajan mentioned is that there is going to be overlap between medtech and medical and services. That is actually, in fact, true. This is an act which is a watershed moment in India's legal history of right to privacy and data management. It will impact every sector. Speaking for myself, I usually am engaged to represent clients in courts, whether it be in commercial matters or medical legal issues or regulatory aspects. I also do a lot of policy based challenges in courts, and therefore I tend to look at new laws and new regulations from that perspective and from that viewpoint. This act is definitely an important piece of legislation, the DPDP Act read with the rules. And I'm just going to start my presentation. If yes, it should be here. Are you able to see my screen? Yes. Right. So the DPDP Act is indeed a watershed moment. It brings the power back to the individual and places the citizen in the front and center, giving them control over their personal data and confidence that it is being handled with care. It also puts a tremendous amount of an obligation upon the data processor as well as the data fiduciary to deal with this data with respect and to treat it in a manner which keeps the data secure and always within the control of the data principle. I'm also very, very grateful to my panelists today who will be hearing from their, after I'm done. They're experts in the field. They're all living the reality. I mean, I'm looking at the law and conjecturing what could be possible challenges based on what certain clients bring to me and certain other individuals bring to me. Here we have individuals who are actually living it, and they will tell us more as to how they're putting the law in practice and what kind of challenges they're facing, which I think is invaluable for all of us trying to understand this law as we move forward. Some basic concepts I'll quickly go over so that we're all on the same page when we consider the law. The definitions under the DPDP Act become very important. Data is an extremely wide definition. It means a representation of information, facts, concepts, opinions, or instructions in a manner suitable for communication, interpretation, or processing by human beings or by automated means. Importantly is the definition of personal data, which is what this act is dealing with, which means any data about an individual who is identifiable by or in relation to such data, which is important because in this definition, there are two major aspects that stand out for me. One is that it refers to data about individuals. This is an individual based act. The scheme of the act is to consider all such data which are in relation to an individual. But what is important is the individual should be identifiable by such data. And as we will see later on in our discussion, an important aspect becomes what happens to anonymized data or data from which the individual can no longer be identified. Would that fall within the domain of this act? At first blush, it would seem that this act is intended for all such data from which you can identify the individual to whom the data relates. Data principle means the individual to whom the personal data relates, and where such individual is a child, it includes the parents or the lawful guardian of such a child. And where such a person is with disability, it includes her lawful guardian acting on her behalf. Data fiduciary is a very important concept for all of us to understand, especially when looking at it from a commercial point of view, as people who will be collecting the data of our clients, our customers, and other individuals. It means a person who, alone or in conjunction with other persons, determines the purpose and means of processing of personal data. This definition becomes important when you consider the next one, which is data processor. It means any person who processes personal data on behalf of a data fiduciary. Now, importantly, data may be processed by various individuals. A person may even hire another person to to convert the data into statistics, to do any kind of processing on the data. If the decision as to what kind of processing is to be done on the data is not being taken by the actual person performing the operation, the individual may only be a data processor. The obligations under the act and the onerous responsibilities and the liability is all upon the data fiduciary and not upon a data processor. Therefore, it will become very important to identify very quickly for us as to whether we will fall under the definition of a data fiduciary or whether we will fall under a definition of data processor. If we are going to be a data processor, to make it absolutely clear in all our communications and contracts that I am only the data processor, not the person who is actually taking the decision as to what data is to be collected and how the same is to be processed. Therefore, the concept of data fiduciary and data processor are extremely important for us to understand the other provisions of this Act. Now, an extremely important definition under the, I'll read it and then I'll explain what I've understood from that definition. Processing in relation to personal data means a wholly or partly automated operation or set of operations performed on digital personal data and includes operations such as collection, recording, organization, structuring, storage, adaptation, retrieval, use, alignment or combination, indexing, sharing, disclosure, by transmission, dissemination, or otherwise making available, restriction, erasure, or destruction. So, therefore, every and any means of treatment of any data, including the storage, transmission, and any kind of structuring of the same, will be considered processing. Just when the meeting was started, I saw a message on the chat box, and I thought it meant that someone would be taking notes. That brought a very interesting question to my head. I know there are several apps nowadays which converts speech into text writing. According to me, that may also fall within the definition of processing, because if you look at the definition of data, it has within it the word opinion. Therefore, all of what I'm saying right now, being my opinion, if it is converted into writing, it may also be considered as processing of data. So, processing, frankly, is an extremely large and wide definition. The words which are a bit worrying for me are the words right at the end, which state erasure or destruction. And I've said so in the previous webinars in the same series. Erasure and destruction, also falling within the definition of processing, would mean that one can't even delete data without taking consent for the same. Because the Act requires consent for every part of processing. For any processing of data, you need specific consent. Therefore, even for deletion and erasure, a classical and conservative view would be that one would need to take permission for doing the same. A significant data fiduciary is a data fiduciary or a class as may be notified by the central government. We'll deal with that in a bit. Specified purpose is an important point. The consent that will be taken under the Act, the notice that will be provided to the data principal will have the purpose specifically mentioned. It is no longer appropriate under the new regime to state in a generic manner that your data shall be used for A, B, and C and other things of a like nature. It has to be specifically mentioned as to what the data shall be used for. A consent manager is a person who will be registered with the board. He's a new entity being created under the Act who has a fiduciary responsibility to the data principal. He acts as a single point of contact to enable the data principal to give, manage, review, and withdraw her consent through an accessible, transparent, and interoperable platform. Now, when we come to the med tech industry, it's a new industry in the sense that it's a constantly developing and a dynamic industry. And of course, the nature of that industry and the challenges our experts will tell us hereafter. But from what we could make out, the IoT wearables become an extremely important point of convergence of the technology as well as the Act. The information that is being collected, the information that is being presented, the processing of the information, that is all going to fall within the domain of this act. Therefore, the consent that will have to be taken will have to be extremely specific. From time to time, the data that is being used and that is being presented, who it is being sent to, where is it being stored, is it on a cloud, all of that will become very important. It will become important to disclose the same, and it becomes extremely important to safeguard that data and ensure that it is not lost or accessed in any unauthorized manner. Devices intended for minors must implement verifiable parental consent. We will deal with that a little later when we deal with what are the requirements under the Act for children and the disabled. And the privacy is a requirement, it's a must under the Act, and it applies equally to the medtech industry. Now, essentially what this slide is going to show is that all of the provisions of the Act, that is the relevant ones, such as Section 3, Section 5, read with Section 6, which is notice and consent, the rights of the data principals, the obligations of the data fiduciary, they have a trigger date and they become effective from 13th of May 2027, giving enough time to every entity. And as I mentioned right in the beginning, this act does not distinguish between sectors. It does not distinguish between industries or even the size of the operation. Any person under the sun who is collecting data, personal data in digital format, is brought under the purview of this act and therefore has to be in compliance with the requirements under the act. Now, before I get to the rights of the data principal, there are certain provisions I'd like to bring to the attention. And in this regard, I think it becomes important to consider Section 3. Section 3 of the Act states that it will apply to the processing of digital personal data, which is collected in digital form. That is, of course, it's a no-brainer. When you're collecting digital data in digital form, personal data in digital form, clearly the Act applies. But it also applies to non-digital data, which is subsequently digitized. And I think that becomes important because, as we all know, there is always data available with several entities. We always have data in scanned formats, which may also be available in the actual hard copy. Anything that is digitized, that was collected prior, that is collected today, that is kept in digital format, this act shall apply. It also applies, I must make it clear that this act also applies to all of the previous data collected. Section 5.2 becomes important in that regard, which says that where a data principal has given her consent for the processing of her personal data before the commencement of this act, the data fiduciary shall, as soon as it is reasonably practicable, give to the data principal a notice in the same form as is required under this act. There is no look back period. There is no period saying that 1 year before the enactment of this legislation or for the previous 5 years. It simply states that where you have data that was collected prior, one will need to take steps in accordance with the current provisions of the DPDP Act of notice and consent, and bring that notice to the attention of the data principal and seek consent. The only leeway and the only room given for all such previous data is the terms as is reasonably practicable. We are one judgment away from understanding what those words mean, but until then, one could take the liberty of knowing that if it is extremely onerous to go and take that consent, or to take consent from each of your data principals, there is room under the act, but the obligation doesn't go away. One will have to take steps, and my recommendation is those steps be taken sooner than later to start getting that consent, not only for data being collected from today, but for data that is previously collected, which one is continuing to maintain. Now, the other important aspect is the requirement of notice. Now, everybody talks about consent being required, and that is absolutely right. The data principal needs to give specific consent, which is provided for in Section 6. I'll come to that in a minute. But one must not overlook the requirement to provide notice. And the requirement to provide notice comes under Section 5 of the Act, which states that every request for consent to a data principal must be preceded by a notice giving the data fiduciary, given by the data fiduciary to the data principal, which is specifying the purpose for which the consent is being sought and the manner in which the data will be processed. Why this notice becomes important is that I can quite understand that an app may simply ask you to give a consent and move on. But there is a requirement under the Act for a notice, not only under Section 5. I must also inform you that under Section 610, it states that where there is any question with regard to the processing, the data fiduciary shall be obligated to provide that a notice was given to the data principal. So it's not an empty formality. This notice, and something that I have also subsequently realized how important it is after my last two webinars, actually in a live matter with a client, that we realized that notice becomes extremely important. It is something that you will not only have to provide, but you'll also have to maintain in order to be able to show, because the act will require you to prove that you issued notice. So therefore, under Section 5, for all apps, all softwares, every service provider, please bear in mind that your notice format must already be in place. It must be specific and clear in terms of Section 5 and Section 610. In fact, one may also note Rule 3 of the rules specifically provides for what will be the requirements under the notice. It will be in one of the languages under the schedule of the Constitution, specify the data and the treatment of it all. Now, Section 6, I'll come straight away to the rights of the data principal. Under the Act, the data principal is supreme. Therefore, the data principal not only has the right to consent, he also has the right to withdraw his consent at any time. He has the right to information, where he can seek information as to how his data has been processed and who the data has been shared with. All such information is a statutory right enabled to him under the Act. Therefore, the data fiduciary will have to maintain a record of how such data has been processed, where the data is located, and who all the data has been shared with, which could include other data fiduciaries as well as data processors. There is a right to correction if there is any error or any updation required in any record. I know here we're talking about health records specifically given the medtech industry, but this is true for any record that a person may have which pertains and falls within the definition of personal data. That data has to be updated and corrected by the data fiduciary upon request by the data principal. A data right to erasure, this becomes extremely important. I mentioned already that destruction and erasure already falls within the definition of processing. But that only means that when a data fiduciary would like to deal with the data, including deleting the same, one should require consent for the same. But if the data principal asks that his or her data must be deleted, the data fiduciary has to take steps forthwith to delete such data and to delete the data even from the data processes. Lastly, an important right given again to the data principal is a right of grievance redressal. It's a statutory requirement for every data fiduciary to appoint a data protection officer and to have a grievance mechanism in place which will be answerable to the data principal. It's important because as we are all aware, there will be a board that is contemplated under the Act. The board will have powers of investigation and even powers of penalty, but there is a requirement for the data principal to go through the grievance redressal mechanism before the person can go to a board. Therefore, grievance redressal is an essential and an important requirement for every entity who is dealing with personal data for customers and clients. Now, there are certain timelines which are mentioned under the Act. For example, sections 1 and 2 of sections of the DPDP rules require a breach intimation to the Data Protection Board, which states that the minute there is any breach. Now, this is a step away from the GDPR, where if there is a breach of substantial risk, one is required to inform the regulator as well as the data principals. Under the DPDP Act, however, the minute there is any breach, without delay, one has to inform the board as well as the data principal that there has been a breach. It is within 72 hours after that that a detailed report can be provided to the board, estimating the loss, if any, the breach, the cause of the breach, and the steps being taken thereafter. This breach intimation under the DPDP rules is an extremely important obligation upon the data fiduciary. Failure to do so has grave penalties, as we will see right at the end. There is also a requirement for a data deletion, as I mentioned. 48 hours prior to deletion, a notice must be given to the data principal that your data is being deleted. If you are assigned the role of a significant data fiduciary, from a yearly basis, within a period of time, you have to conduct a data protection impact assessment, which will be an assessment as to your existing framework, your infrastructure, and the methodology adopted by you, and how the efficacy of the same. Within 90 days, one must respond to the grievances of data principals. As I mentioned, the grievances redressal mechanism is a very important mechanism, and there is a timeline provided that is within 3 months or 90 days, the grievance must be redressed. If it cannot be done, then the data principal has a right to access the board. Now, an important point is under Section 4 of the Act, there is a provision which states that the data principal data can be used to processing for the purpose for which the data principal has given consent. To put it simply, the purpose which you have highlighted in your notice, for which you've received a specific consent, you can obviously process the data for that reason. Section 4 also says the data can be processed for that purpose or for certain legitimate uses. Now, what the word legitimate uses means, it has not been defined under the Act. And to be very fair, Section 4 doesn't even draw reference to any other provision of the Act to explain what it means when it says it can be used for certain legitimate uses. We therefore come to Section 7 of the Act. Section 7 states the heading of Section 7 is certain legitimate uses. We are therefore reading Section 7 requirements into Section 4 and understanding Section 4 to have reference to Section 7. Now, Section 7 essentially states, as you see the first block, it is for the specified purpose for which the data principal has voluntarily provided personal data and has not indicated that she does not consent to the use. The second is for the state and any of its instrumentalities for any function which is a sovereign function. I'm not getting into that. It may not be relevant for all of us today. For fulfilling any obligation under any law for the time being in force, on any person to disclose any information to the state, again, may not be the mood in which we are discussing the present webinar. For compliance with any judgment or decree or order issued under any law for the time being in force in India, for responding to a medical emergency involving a threat to the life or a severe threat to the health of the data principal or any other individual. This is one of the exceptions that is provided under the Act for the medical industry, which states that once we realize that there is a medical emergency which has a threat to life, then one need not wait for consent and the data may be processed for the purposes of responding to the said medical emergency. Then it is for taking measures to provide medical treatment or health services to any individual during an epidemic, outbreak of disease, or any other threat to public health. Once again, in a situation like COVID, the Act contemplates that it may not be possible to take the consent of the individual, and there is a exception provided. For taking measures to ensure safety or providing assistance to any individual during any disaster, I think it is self-evident. For the purposes related to employment or those of achieving protection from loss of liability, such as prevention of corporate espionage, maintenance of confidentiality. Now, this is the last exception that has been provided. There is no explanation as to what is the meaning of such a provision. Now, when it relates to employment, how is the data being processed in a manner without the consent so as to prevent corporate espionage or maintenance of confidentiality? It's really open to conjecture and it's on a case-to-case basis. But here is another situation where the law contemplates data processing to happen without the requirement of a consent. Before I move on, I must bring to your attention Section 6.1. It says that the consent that will be given by the data principal shall be free. Therefore, there can be no mode of consideration for the consent of data processing. It shall be specific, informed, unconditional, ambiguous, and for the specified purpose, and will be limited to such personal data as is necessary for such specified purpose. Therefore, if the email the phone number, etc., is not relevant to the purpose with which the larger data is being collected for the processing, that consent may not be used for the sharing of the personal data such as email IDs and phone numbers, etc. The law is clear. It is absolutely specific, unambiguous consent that must be taken only for that portion of the data which the fiduciary thinks will be useful for the processing for the purpose mentioned. Section 6(4) says that the data principal will have the right to withdraw her consent at any time, with the ease of doing so would be comparable to the ease with which such consent was given. It means that the data principal can withdraw at any time. Once the consent has been withdrawn, the data processing must be stopped within a reasonable time. The law does warn the data principal that the consequence of you pulling out your consent will be borne by you. For that, if you do not get the service any longer and if you have to suffer, then the consequence is upon you. It does create an exception which says that if the processing is required under any other law or the rule for the time being in force, then the processing may continue even if the consent has been withdrawn. Lastly, what is important is that Section 6(3) and various other sections does require every data fiduciary to appoint a data protection officer. A big point of discussion is that once an industry or any data fiduciary is appointed or nominated by the government to be a significant data fiduciary, several obligations fall upon the significant data fiduciary, and the Act requires, specifically mentions, a data protection officer to be appointed. However, there are various other provisions which we have noted in the Act, such as Section 6(3), Section 8(9), and Red Rule 9, which seems to indicate that every data fiduciary will have to have a data protection officer and a grievance mechanism. So it is no longer, or actually never been, an obligation only on a significant data fiduciary. Every entity, no matter how big or small, dealing with personal data, which falls within the definition of this Act, is required to have an officer assigned as a data protection officer who will be answerable to the data principal. I'd like to bring the attention to the action items that may be required for the medtech industry. First and foremost, as Section 8, and it may be relevant for all of us to remember, Section 8 provides for the obligations of a data fiduciary, and there are several obligations. An important principle to keep in mind is Section 8(1), which states that the data fiduciary shall, irrespective of any agreement to the contrary or failure of a data principal to carry out the duties provided under the Act, be responsible for complying with the provisions of this Act and the rules made thereunder in respect of any processing undertaken by it or on its behalf by a data processor. An extremely important section. Let me break down some of the key ingredients of that section. What it means is that irrespective of any agreement, therefore, you cannot have an agreement to bring in disclaimers. You cannot have an agreement which outsources your responsibility or your liability as a data fiduciary under the Act. Secondly, even if there is a failure by the data principal, that is the individual, to perform its obligations under the Act or to enforce its own rights under the Act, it does nothing to the liability of the data fiduciary. Even if there is a mistake by the data processor, which is demonstrably a mistake of the data processor, it does nothing to the liability of the data fiduciary. So the law fastens the liability and the responsibility on the data fiduciary very clearly and states the minute you collect personal data for any purpose of processing as identified by you, you are responsible for that data, irrespective of what agreement you may have, which may reduce your liability, limit your obligations, irrespective of any contract you may have entered into with the data processor, irrespective of any breach by the data processor or by the data principal. It is you and only you who is responsible to ensure that the data is protected, the data is safeguarded, and the privacy of that data is maintained. Therefore, that is an extremely important aspect for all of us to bear in mind as data fiduciary. Keeping that in mind, please now consider what Section 8(2) says, that for a data processor, there has to be a valid contract. Therefore, if you're engaging with any entity to deal with the data. It is not all right to have an oral understanding, to do a contract, which may be a click contract, etc. The law requires there to be a valid contract. So therefore, all your vendors, all your data processors, please ensure that there are valid contracts with such vendors, data processors, etc. The contract can be easily understood. It is enforceable. Please build in your indemnities under the contract. The liability must be coextensive with the liability under the Act for the data fiduciary. Because if there is an issue that happens at the data processor's end, it will be you who's responsible, but you must have the ability to reach out to the data processor and have your losses be recompensed and be indemnified by the data processor. It is important to train your staff. It is extremely important to sensitize the staff on notice requirements, not to collect data where it is not relevant, to collect only such relevant data. In fact, on the previous webinar, we had a data protection officer from one of the hospitals, and I loved the line that he said, and I've noted it. He says, "Our philosophy is to convert our entire staff into an army of DPOs." And I thought that was an excellent philosophy, that every single individual in the organization is aware of the requirements under the Act, will act as the DPO, being responsible to the data principal for the data, knowing why the data is being collected, what data is required, to not seek that data which is not required, and be absolutely aware of the requirements under the Act. Without such a philosophical change or a cultural change in an organization, it is very difficult to ensure that the requirements, very stringent, very forward looking requirements, putting the individual in the front, is not complied with by an organization. One must update consent forms, as I mentioned already. Before consent forms, please incorporate a notice. It is not, you may call it whatever you like, you may structure it however you deem fit. We've already started advising some of the people who've reached out to us. The notice is a requirement. Please bear it in mind. Don't call it just a consent form. Call it a notice and take a consent thereafter. It, for whatever it is, there is a saying, good, bad, or ugly, the law is an ass, but it is what it is. There is a requirement for the notice. Let's comply with the requirement of a notice and a consent. Mechanism for withdrawal of consent is also equally important. It has to be provided. Your consent form, your notice must state the rights of the data processor, including what he needs to do, who he needs to get in touch with to withdraw his consent, who is the grievance redressal officer, and the mechanism provided, and the ability to reach out to the board in the event of a breach. All of this is a requirement under the law that your notice and the consent form must have. We must have a clause for erasure of data. Now, for a lot of the medtech companies, a lot of service provider, a lot of technology based companies who are taking consent, who have data, it is entirely possible that there may be a situation where your technology service is no longer being used. You may want to have the right to delete data to move on, to not deal with the data any further. Please build that specific requirement into your notice, stating in such circumstances, by giving you a 48 hours prior notice, which is a requirement under the Act, we will have the ability to delete the data and you're specifically consenting to the same. It is my recommendation, and I agree that this may be a very conservative view, and I must candidly state several practitioners that we have had a discussion with don't see the definition of processing in the same manner that I do. They don't read the words erasure and destruction in the same manner as I do, but it is one judgment away from absolute clarity. Until then, my recommendation is the words erasure and destruction under the definition of processing cannot be ignored and cannot be belittled in light of the other languages. We must therefore take specific consent for even deletion of data, which will be considered as processing, according to me. We must create clear procedures for handling users' requests to exercise their rights with respect to inaccurate or misleading personal data, to complete the incomplete personal data, and to update personal data. I want to bring to our attention section 8.3, which says that where personal data processed by a data fiduciary is likely to be used to make a decision that affects the data principal or disclosed to another data fiduciary, the data fiduciary shall ensure its completeness accuracy, and consistency. It's a interesting provision which again puts the onus on the data fiduciary. What it says is if the data processing will lead to a situation where the processing of the data will cause the data principal to take certain important decisions, or if you're providing that data to any other data fiduciary, it is the data fiduciary which has to ensure that that data is complete and accurate. Surprisingly, the onus is not put on the data principal to ensure that the data is clear and accurate. It is the obligation on the data fiduciary. Once again, therefore, the philosophy being, the scheme of the act being, that the data fiduciary has to take complete responsibility for all data that is with it and for all data that it then transfers to the data fiduciary, or for the processed data which will be used by the individual for taking decisions. I've already dealt with the digitization trigger. I've mentioned that it is for all data that is collected in digitized form. It also refers to all data that is subsequently digitized. Therefore, the entire gamut, whatever data is there in digital format collected now, tomorrow, or earlier, is within the definition of DPDP Act. Notice and consent also I've dealt with. I mentioned it is to be in languages which are under the 8th schedule, and it has to be specific and also provide a mechanism for withdrawal of the same. Now, under the section 8(5) of the Act, it requires that the data fiduciary shall have to protect the personal data in its possession or control, including when the data is with the data processor, and will have to take reasonable safeguards to prevent the data breach. I must also bring to your attention, this has to be read along with Rule 9, this has to be read along with the rules which provide under Rule 6, the reasonable security safeguards. There are about 6 safeguards that are provided, which states that at minimum, the words used is the security safeguards shall be taken by the data fiduciary, which shall include at minimum. So therefore, A to G are provided under Rule 6. Each of those requirements, including technical requirements, have to be maintained by the data fiduciary. Now, one may have a more advanced methodology of securing the data, which I'm sure our experts today will deal with, and that is fine and great. But one has to ensure that A to G under Rule 6 of the DPDP rules are met with, because it is an at minimum standard. I've also talked about erasure and notification. Both of those are extremely important as well. That's now when it comes to the significant data fiduciary, there's a classification criteria. We don't know today what is the exact criteria for a data fiduciary to be determined to be a significant data fiduciary. It may be based on volume, that when large scale data is being processed by the data fiduciary. It may be based on sensitivity. These are the two qualification criteria that is mentioned in the Act. And it essentially states that the central government shall by notification notify certain industries or certain specific entities to be significant data fiduciaries. Once that appointment happens, and if we fall within the definition of significant data fiduciary, and I think it's as a rule of thumb, it may be prudent for all of us dealing with medical data to assume that that will fall under the category of sensitive data, and therefore some obligation of significant data fiduciary is necessarily going to fall upon us. It is maybe important for us to be prepared for the same. One will have to appoint a DPO, but as I mentioned, it is whether you are a significant data fiduciary or a data fiduciary, you're required to appoint a DPO. There has to be an independent audit by a data auditor, and as I mentioned, the data protection impact assessment must also take place. Data fiduciary versus data processor is a very important definition. We in the industry, when we're dealing with the services that we're providing, we will have to quickly identify whether I am only a service provider to a data fiduciary, in which case I'm a data processor, and therefore obligations are limited or lessened upon me. Obligations will be only for the data fiduciary who is entrusting data to you for performing certain processes and operations upon such data. It's a contractual liability. But if you are an entity which is collecting the data, deciding what data is to be collected and how it is to be processed, chances are you will be under the definition of data fiduciary, in which case all of the obligations under Section 8 become applicable. Minors and disabled have a special position under the law. Data that is being obtained from a minor has to have a consent of a parent or a guardian. What is important under the rules is that there is no specific obligation upon the data fiduciary to verify that the person giving consent is actually the parent. It is actually the requirement seems to so far only specify that the information that is being collected is of an individual and the consent is being taken from an adult who is verifiably an adult. Now, when it comes to the disabled, the position changes because now one is supposed to verify not only that the individual is an adult, but also that the individual is the lawful guardian of the data principal as under law or by any order of any authority or court. Penalties and adjudication. An important point here is penalties are large. As I mentioned, if you fail to take security safeguards, and I'm again reiterating, there is a at minimum standard adopted by the law under Rule 6. The penalty is up to 250 crores. If there is a failure to notify the board or the users of a breach, as I mentioned earlier, there is a difference between the GDPR and DPDP Act. There is no minimum standard, there is no minimum threshold. It isn't enough to say there is a small data breach which would have had no impact. The law requires every data breach to be immediately intimated to the board, followed by a detailed report within 72 hours, and immediately to the data principal. Failure to notify again has a penalty which can go all the way up to 200 crores. Importantly, the law as it stands today does not provide for a compensation to the data principal, which may be useful because the data principal may not look to benefit personally by any breach, and therefore chances of an abuse of this process, an abuse of the law, or an attempt to profiteer by claiming breach may be lessened because none of this penalty goes to the data principal. As far as the law today stands, it is taken into the Consolidated Fund of India. That is all from my end. Of course, once the experts have dealt with their view, we can deal with any of the laws and how it deals with the medtech. Thank you.
Thank you very much, Tisham, for I think a very comprehensive, uh, review of the act, the rules, the impact that it has. And Rohan, you want to come in?
Yes, sir. So we would like
Over to
to
you.
now invite Ms. Anusaya Mohan Roy for her perspective on the medtech industry.
Thank you so much. And is my audio clear? Just wanted to confirm.
Yes,
Yeah,
absolutely
yeah,
clear.
yeah. Thank you so much. So, first up, glad to be part of this webinar. And every webinar that I attend, thanks to Mr. Sain and all of the fellow panelists, there's a lot that I have started to learn. So let me also start with what it means for me and my role as a clinical partnerships leader, and specifically from a DPDP standpoint, what I take back is that every partnership and every collaboration must be designed as per the appropriate roles. Yeah, whether it is the role of the data principal, the fiduciary, as well as the data processor. Yeah, and another aspect that comes very strong is that trust of the patient and the integrity of the consent, as well as defensible data governance, is something that is becoming foundational to innovation. And Mr. Sain also spoke about contracts, and that is also a very important and an obvious focus area for me. So, having stated some of these aspects, I wanted to bring in, from a medtech standpoint, I see that there are three structural shifts that we need to bring to the table. And specifically, I'll focus on compliance, data governance, and risk management. So, I'll start with the first one. So, as medtech, as part of the medtech industry, there needs to be a fundamental shift from regulatory compliance to engineered trust. And this is where Mr. Sain was also referring to a culture change, and that is what I mean. So let me delve a bit deeper into the first aspect, right? So historically, compliance meant meeting regulatory checklists, whether it is from a safety standpoint, whether it is from a quality system standpoint, and all of the associated documentation. Now, today, with the connected devices, the IoT enabled devices, the AI enabled software, as well as the cloud based ecosystems, we are now exposed to patient data at a massive scale. So, privacy, cybersecurity, and related aspects can no longer sit in SOPs or legal agreements. So, those aspects need to be embedded in the product architecture. And what needs to be engineered from day number one is keeping in mind with the purpose and the limitation of that purpose, being very knowledgeable about that, being aware of the consent and the associated traceability, the data minimization, encryption, and secure design. So, all of these aspects need to be engineered from day one. And under this particular act, we are not just manufacturers, our accountability increases, and trust is going to be an important product feature. Yeah, so that is the first part that I want to emphasize. Now, coming to the data governance part of it. So, I fundamentally believe that we need to elevate the AI data governance to the same level as the governance from a clinical evidence standpoint. So, through the course of the years in medtech, we have rigorously validated clinical performance, whether it is the sensitivity, the specificity, or the reproducibility. Now, with all of this, we need to apply the same discipline to data provenance as well as the life cycle governance. So, for example, where did the training data come from? What is the data collection mode? Is it prospective? Is it retrospective? And another important aspect, something that Mr. Sain alluded to, was the consent valid for this purpose? And for example, if we want to do some more improvements for an AI enabled solution, is this use of the data for secondary use, is it defensible? And another important aspect is, can the imaging data, when combined with the metadata, can it re-identify individuals? So the risk here is not just the algorithmic bias, it is consent integrity, it is traceability of the data sets and explainability under this regulatory scrutiny. And I also want to state very clearly that in this, as we move towards this, data governance is something that must be alongside clinical, regulatory, as well as quality governance. So that's the second part. Now, the third part that I want to allude to is how we need to integrate risk management across the entire ecosystem, because the liability is not something which is diffuse. So we see that across the ecosystem, the medical data flows across hospitals, the OEM partners. It could be the cloud providers, AI vendors, research collaborators. It could global teams are involved. So while the data flows, the accountability does not get fragmented. In fact, it is concentrated, right? So as part of this, as medtech companies, we need to align on the role clarity, the contractual role clarity, fiduciary versus a processor. We also need to keep in mind the cross-border data transfer safeguards, something that I also alluded to in the previous webinar, the cybersecurity controls, as well as the post-market surveillance data handling. So risk management can no longer be siloed into either regulatory, IT, security, or legal. It's something that we need to keep in mind, and it needs to be integrated into one coherent governance framework. So essentially, as medtech, we need to align contracts, the cyber security safeguards, as well as all of the operational risk management into one integrated governance model. So I just wanted to wrap it up by saying that for us as medtech, if we want to lead responsibly in the AI era, we need to shift our thought process from not just can we build it. Now we need to move to can we really defend how we built it, trained it, and governed it. So that is the shift that I think this brings in, from compliance more as an obligatory aspect to governance as a competitive advantage. So that's what I would like to wrap it up with.
Well, thanks for the remarks, ma'am. Shall we now move on to Mr. Raju Ramprasad to give his kind remarks and take this discussion forward?
Yeah, definitely.
We can't hear you as of now. Yes.
Sorry.
Yeah, am I audible now?
Yes, sir. Please.
Perfect. Yeah. Thank you so much for that, Rohan. It was a great start by Dr. Mahajan and Mr. Sen. So from my standpoint of view, so most of these opinions of mine are personal experience-based opinion. Nothing has to be attributed back to my employer. And like how Mr. Sen said at the beginning of the call, all of us are living currently in the octagon trying to fight what is coming our way. From a DPDP standpoint, one of the things that I have always struggled with, not just in the recent times, also in my past roles, has been what do we do with the legacy data? This is something that we go one step further from a consent-based, a specific granular consent-based opt-in requirement to see what we are doing essentially with the past data. The DPDPA goes into talking about cross-border data transfer. It talks about how consent needs to be obtained. It talks about exemption. It also specifically talks about how to continue processing data that you've already held up until today. The BAR Act says that you either obtain fresh consent before the law goes into place or continue processing until the data principal pulls their opt-in or pulls their preference out from. So this is a very nuanced, challenging concept because uh, over the past, let's say 5, 10 years, whatever data a company has collected is essentially being stored in the backend on multiple cloud servers. The data that was collected probably in 2020 would be put to use for different purposes than what it was currently, what it was originally collected for in 2020 when compared against 2026. That brings us into a purview of how medtech companies need to work around this because medtech companies, not just medtech companies, any company in the healthcare sector collects massive amounts of data, which is being archived, which is being stored for purposes not just such as R&D or pharmacovigilance requirement. These could be even for legal requirement to ensure that we are able to protect ourselves from any future liability or legal suit. But the purpose for which we collected the data, let's say for back in 2020, might not have even been accompanied with a granular, extensive, privacy notice or statement. And as the law goes into effect by May 2027, and as we are seeing the proliferation of AI and ML in almost everything that we do today, one of the most important things that I feel would be that we really go back and do a clear cut, record of processing activities and create a very good data inventory. While the DPDPA in itself does not talk about or does not have the requirement to carry out a ROPA, being proactive and carrying out a ROPA actually cuts about 60 to 70% of any overhead that one might see when they start trying to implement the law in their local organization level. And creating a ROPA essentially helps you understand what data was collected, at what point, why was it collected, and what has happened to it historically, and what is the intention going forward. One of the things that I very specifically look forward to from the teams that I collaborate with is that they tell me what is the exact purpose for which they've collected the data and for how long that they would be using it. So for me, beyond purpose minimization, a purpose specification is what that I usually look forward to, because that gives me a understanding of what level of security and admin level access do we need to have in place. What sort of security controls do I need to put into place if this is critical data, non-critical data, patient health data? And I did see one of the questions that spoke about continuous data monitoring through Bluetooth connectivity. So we need to also see if this was something that was done prior to the DPDPA coming into place, and how you will be putting that data going forward. One of the examples that comes to my mind is a health tracking device called Whoop. I don't know how many of you use it over here. It's essentially on our wrists 24/7. So this was a device that came into place maybe a couple of years ago, but other options such as a pacemaker or a O2 monitor or a blood glucose monitor, these are hardware-based devices that are currently being changed into software models, which could also use legacy data. So the most pivotal point that we would go into looking at as a data protection officer or a privacy manager, or any role that involves privacy compliance and risk management, the first touch point would ideally be legacy data. Do you need that? How are you going to go forward with it? And to see what sort of compliance requirements falls onto you from a significant data fiduciary perspective, if you are one. And in most cases, it's always better to be more cautious than not. If we are handling, patient health information, if you're handling, critical health information about our patients in a clinical study or in a trial or in a real world evidence collection procedure, one of the best ways to do it is to work backward while thinking that we need to be 100% compliant with the law by May 2027. So legacy data, while keeping in mind the increase in how corporations these days are putting into use AI and ML models, would be the first touch point for me while implementing the current DPDPA law in any organization. And that would be my very 30,000 feet perspective view on this. Back to you, Rohan.
Hi, Rohan, are you there?
Yes, sir. I was just wondering if that would be all.
No, I'm done. I'm done. Yeah,
Okay,
back.
and thanks for calling, sir. Shall we now invite Ms. Shivani to give her perspective and take this discussion forward?
Yeah, hi. Are you able to hear me well?
Yeah, yes, ma'am. Yes, ma'am.
Yeah, thank you. Nice to be part of this forum, and I think it's a personal learning for me as well. Um, uh, uh, the previous speakers have already covered a lot, but I will talk about, as a security person, I will talk about what I saw in terms of security and security controls, right? So this law actually talks about reasonable security controls to be in place, and notification to the CERT team if there is any breach. And as the previous speaker already mentioned, there is no quantum of breach. Even if there was no breach and there was an attack that happened, it is important that we notify. And that is really important. Coming back to the security controls, right? When they say it is reasonable security practices, it is not about doing something bare minimum. It is about having security by design and privacy by design. And security falls under the larger ambit of privacy. And so having security by design is very, very important. For companies like us, GE Healthcare, since we already abide by HIPAA, GDPC, and other privacy and security laws of the globe, DPDPA is already inbuilt into our product design. So we do not have to do too many things that we are not already doing to be compliant with DPDPA. But yes, integrating with the consent management platform that would be certified by the government is something that we are looking forward to. On the vulnerability assessment and penetration testing requirements for and security audits that are there, the Act says that there has to be a regular audits and vulnerability testing. We at G, or my personal recommendation would be that we keep a tab on the assets that we have, and we keep a tab on what exactly are we developing, and what is the process of our development of our complete software development life cycle, and what are we introducing new in a year. And if the number of features or new things are getting introduced at a very shorter time span, if it is a cloud-based solution and new features are coming in at regular intervals, then the vulnerability assessment, testing, collection of software bomb, and ensuring that the end of life of your software bomb and the risks associated with it are addressed, and risk-based analysis is done at a very regular interval is very, very important. But yes, if the number of changes are less, then you can always do it at a bigger period, like once in a year or once in 6 months. So it all depends on your risk assessment. So it's important that there is a proper risk assessment framework for your security vulnerabilities in place, which includes having a proper threat modeling exercise, having a proper scans with the right tools in place, and someone who looks after those scans and the reports. With that, you will know as to what is that period at which you need to perform your penetration tests, at which you need to perform your software patching and all of that. So having that eye on it and having a proper framework to do the risk analysis is really important. And that would be my most important takeaway from the law and as a security person. And the other one is continuous monitoring and logging, and ensuring that nothing from the personal information of the patient gets logged into the logs. And we have a mechanism to be continuously monitoring and ensuring that the law also has a 1-year mandatory log retention policy. So we need to ensure that we are able to retain logs for a period of 1 year. And so we have to keep a tab on the size of the log, and we are logging what is really essential and not everything, because it will take space and will cause other problems. So having that performance tests done and all of that is also equally important. So that was my 2 cents on the security angle of this thing. But I'm happy to take more questions if there are any, and would like to pass it on to the next speaker.
Thank you for your remarks, ma'am. Mr. Singh, should we move towards the Q&A session? Or
Yeah, certainly. I mean, subject to what Dr. Martin said.
At the outset, thank you very much for a lot of gyan that has been given, and the simpler you make it, the more onus you're putting on all of us, whether it's healthcare service providers, medtech, software as a service, cloud, all of that. And I think if we are ready, we still have about a year plus to go. But I think the major task before us as a industry is that where we feel that that there has to be differentiation made between the healthcare sector and the other sectors, be it fintech, be it these people who the Zomatos of the world who supply food, and I mean we are all actually put in the same basket.
Yeah.
And as you showed, sensitive information will actually put us in a higher category where much more responsibility would be on us, and that much more stringent aspects of the law would come onto us. And that's where I think we need to all get together as an industry and see what are the ways in which, number one, of course, it's important that data be protected, privacy be maintained, and the chance of anyone getting into your systems be reduced. But at the same time, certain unique factors of data collection that are there in the healthcare sector, especially where patients' medical history, reports, treatment, all that is concerned, I think we will have to, in some way, approach the government and in a very constructive manner to see that the desire behind the DPDP Act is fulfilled and is maintained, and but at the same time, some of the complexities of healthcare data don't end up making the whole exercise or treatment delivery or medical equipment becoming much more expensive. And we have people fearing coming into the healthcare sector. That I think is something which we have to look at. And there I think legal luminaries like you would have to help us as to which are the, parts of the act and rules which would need to be looked at, and maybe we go to the government asking for changes so that the desire behind the act is met, as well as it's not unsurmountable for us to be able to follow the letter and spirit of the act. So that I think is where these 3 webinars would be very useful, of having brought different players within the ecosystem together. And this is where, going forward, I think it's up to FICCI and its leaders to bring people together and be able to go over each aspect and ask for modification. Having said that, I would like to thank each and every one of the speakers for their insights. And if I could, some of the questions that have come, one of them again takes over from what has been already discussed by Mr. Raju about legacy, data. Now, let me ask a question which has been asked. Can previous legacy data present now be just deleted? You say that, of course, you save data as per the present law of the country. And apart from that, someone may say, why am I hanging on to so much data if it is going to become tough for me to keep saving it, preserving it, and let me just get rid of it? Would it be possible to, get rid of whatever data which the present law in force, which is in cognizance with that law?
I think that's a very interesting question. And frankly, interestingly enough, I think some of the other clients have also been discussing on similar lines. There is, I mean, maybe that wasn't the intended effect of the act, but there's a quite a strong push to go back to hard copy and to keep papers in an office rather than go digital, especially for smaller practitioners. Having said that, that question is an interesting, I mean, it's an interesting point. I don't think there is a answer fits all kind of an answer here. I can't say that, yes, please go ahead and delete all the data. because it may be subject to applicable laws on that data and medical, etc. But having said that, the requirement under the DPDP does not kick in terms of section 3, 4, and 5, which will be the ones relevant, because 3 deals with what is the data that is to be saved, and 5 deals with data, the retrospective impact on data. That becomes applicable from May 2027. So strictly speaking, that law is in place, but it is not applicable from today. Therefore, the requirement to seek consent for data previously that you have consent for is also not, in my reading, under section 5.2, not applicable today. Therefore, that data, which deletion of which does not impact the rights of any other individual, that which is not prevented in terms of law or any contract in place, yes, it may make sense from a purely from a compliance perspective to maybe not have that data as digital data as on May 2027, which will then be applicable for that data that is with you in a digital format. I think Mr. Ramprasad also brought up a very important point where he talked about legacy data. I think it's an important point because there is no look back period. But there is that provision which says reasonably practicable. So where it is not possible to actually find that individual, get that information to that individual, seek the consent, the law may be giving us a window to say that, look, where it is not reasonably practicable to enforce and get that consent, I don't need to.
Now, taking this point a little further, suppose I delete any identification of the person whose data I have, legacy. Again, I'm talking in the legacy data, about legacy data, that I delete the names, and even I cannot retrieve them if I want. Then can I save this data?
Yes, I would imagine so. Because the definition of personal data, as we saw, and I'll read that out again from the BEAR Act itself, it says personal data is such data. Just 1 minute. Personal data is such data from which a person can be identified. Sorry, yes, it means any data about an individual who is identifiable by or in relation to such data. So the minute you have anonymized to a point where you no longer can, or nobody else for that matter, can identify the individual to who such data pertain to, that may fall outside the definition of personal data and therefore outside the treatment and the scope of the Act. The other point that may be relevant in this context is section 17, 2 of the Act, which also says that data which is collected for research, archiving, or statistical purposes, if the personal data is not to be used to take any decision specific to a data principle, and such processing is carried out in accordance with standards, then the Act also doesn't apply. So again, data that is used for statistical purposes, empirical data, may not be strictly within the purview of the Act.
Yeah, we discussed this at length last time, and this is one area where at least research and development would not be hampered as long as it's de-identified data that is used. And so that is one escape for not only legacy data, but also data collected going forward. Of course, this would need to be part of the consent.
Correct.
That would be there. Now, let me one by one go over some of the questions that have been asked, and any one of the speakers is welcome to come in. Some have already been, I think, answered also on the chat box. But the first one is for Fiki. Will the recording be shared post-webinar? Rohan, just unmute yourself.
Yes, I'm sorry, I was on mute. I didn't realize. So yes, the webinar would be live on YouTube, and we'll also share the recordings with the participants.
Thank you. Thank you.
Thank you, sir.
So there's Nitin Sharma who asks, consent architecture for connected medical devices from Bluetooth devices. Our app collects continuous physiological data, which is core DPDP territory. What constitutes valid consent for explainable and continuous data collection from Bluetooth medical devices like BP monitor, oximeter, glucometer, etc.?
I think that's a great question, and I think that becomes relevant for the entire, wearable.
Wearables.
Yes.
Yeah.
I think the consent, and already there is some sort of consent that is taken in the apps and whatever little I have used them. But I think now what will have to be the norm is that there has to be a notice where the user will be notified that once you're going to wear this data, or once you're going to wear this wearable, you are aware that your data such as A, B, C, and D, for example, what is mentioned here, BP, oximeter, glucometer, etc., shall all be collected for the purposes of processing the same into a readable format and presented on the app. So some sort of a summarization which is specific as to the data, as to how it will be processed and where it will be available would become important for the purposes of the consent. And one may, again, in light of the erasure and deletion discussion, one may also build in within the notice here that once you stop using it within 30 days or 1 year of non-usage, we reserve the right. You give us express consent that we will. So again, I want to be clear. As a lawyer, I think the language becomes important. Reserving the right may no longer be enough. You will now have to take specific consent. You will have to say you're giving us specific consent that you will that allow us to delete, or we will then delete the data. So it's not I think the structure will have to change such that it's not a generic consent, I consent kind of a click. It will have to be, please go through the same, you have consented to A, B, C. Maybe even have a mechanism, and this another practitioner was telling us in recent times, where it's no longer a tick, I consent and an I agree, but you have to tick on each of the data boxes. So, you say as BP, I take, oximeter, I take. So you have specifically identified the data. There is specific consent, and then thereafter you go ahead with that. And it states that it will be continuously monitored. Data shall continuously be picked up. It will be presented. However, we will keep it safe. The safety of the data will have to be paramount, essentially.
Thank you. Shivani has answered this in the chat box. You want to take it up, Shivani?
Yeah, so I think Mr. Vishampati has covered it better than how I could. But yeah, it falls under an unconditional consent, and the notice has to be well written, as he mentioned, and the consent has to be there. But it falls under that unconditional consent. It is like I cannot give conditions that I give a consent only if this is met, because those are continuously taken. And if it is a Bluetooth, it is important that you also give, because that specific question was on Bluetooth connectivity, right? So it is important that you give the information of how technically that data will be collected and how exactly are you going to process it. That is really something that you have to put, because it is an unconditional consent. Think yourself as the end user, right? If I am the end user and I'm giving my data, I would rather want to understand what is the technology that is kind of collecting my data through Bluetooth, and what am I giving consent? That is the only thing that you have to be very clear about. And I think lawyers like Mr. Tishampati are going to put it in the right wordings. But as a technical person, I can only say that if I'm an end user, as well as a technician who is working on a device that is going to connect the Bluetooth and get the data through Bluetooth, right? It is important that we put that in user understandable way. Don't go with too much of technical terminologies there, because that is going to confuse the users. And in the short term, we get into a lot of troubles, because people will not give consent thinking that something big is there and all. At least in cities like Bangalore or Delhi, where people do understand some bit of technology, but not entirely, it will only cause a lot of confusion. So we as medical device manufacturers, we need to be a little more aware as to what is that wordings that we choose. So it has to explain the thing, but not too much of technical terminologies that will confuse the users. We have to be careful about that.
Thank you. Thank you. Then we have Surinder, who's had a follow-up question. And this is something that you've dealt with, Mr. Sen. What about completely de-identified data, irreversible conversion, whereby you create data sets for analysis? Do we still need consents and notice?
Yes.
I mean, this is actually slightly different.
Yes,
You
it is.
can use the data, but do you need consent
Yes.
at the time that you're collecting the data? And do you need to notify the person that I've de-identified your data now? Can I use it, or I'm using it?
Yeah, I think that's a great question because it's more nuanced than it appears. So yes, first of all, as we mentioned earlier, de-identified data may fall outside the definition of personal data, therefore may not have the obligations associated with that data for the data fiduciary under the Act. However, once the data is being collected, for the purposes of collecting the data and for the purposes of de-anonymizing it, I think the operation of de-anonymizing it will fall under the definition of processing. And it could be anything. It could be really be adaptation, retrieval, collection, recording, anything of that sort is processing. So therefore, consent, specific consent ought to be taken at the point of collection of the data, and the individual must be told that your data is being collected. It shall be anonymized, at which point we will no longer be able to identify your data. Why it becomes important is when the person under the DPDP Act asks, where is my data today? One must be able to say, we have actually, now that I'm thinking about it, there are, I think, layers to it. One will have to take consent to collect the data. One will have to take consent to anonymize the data, which will fall under the definition of processing. Thereafter, if that data is still being saved in an identifiable format and in an unidentifiable format, then for the data that is being saved in an identifiable format, the whole application of DPDP applies. If you're then deleting such that you will no longer have that data, because the way I see it, for example, and of course this may be technical, I may not be completely understanding it, but let's say I have a liver scan of an individual who I want to now de-identify. That scan which is now there will either have to be deleted or it will continue to be with me. So I assume there are two layers here. If I'm deleting that scan such that I no longer now have identifiable data, only the anonymized bit, then I need permission for deletion of the same as well. That's essentially what I wanted to say. Consent will have to be taken for all of the processes. Once de-identified, that data may no longer have the requirement of the protection of DPDP Act. That's, I think, the short answer.
Well, thank you. Much as it's adding to the confusion, but you've tried to simplify it. Only thing is, will healthcare institutions just be doing this,
That's it.
and not treating patients? That is what I'm, worried about. And then at the back of your head, you have that there's a 200 crore sword hanging on your head if something goes wrong. So I think I'm sure the government would be open to looking at all this in the overall scheme of things. But as things stand today, yes, consent for any and everything, unless you've taken it day one,
Yes.
which may become the norm, that as and when we feel the need, we can delete the data. I don't know how many people will consent to that,
Correct.
but maybe that's the only way going forward, unless we are able to bring some nuanced changes in the rules.
No, but that's actually right, Dr. Majan. The law needs to be a little more nuanced and thought through because I think that the philosophy is great, but there are lots of gray areas with a huge onerous responsibility. And the fact, I think the confusion helps only one breed of people right now, that's lawyers, who are going to be looking at this.
But
And
You
I
guys
have
are
a
going to
point.
have a field day. Shivani, I see you also answered
Yeah.
Surinder.
Yeah, I
Please
have
take
a
it.
point
Please
here.
take it
I
from
think
here.
you picked the right thing, and I think this is how they are going to deal with it. They are going to first, while collecting the data, right, when the initial consent is taken, anonymization clause is going to be added there, where they say that we might anonymize this data, and this anonymized data is going to be saved somewhere. And for the medtech industries which are going to take this anonymized data for research purposes and all, they do not have to take another consent is what I'm thinking. And that is how I would want it to be as a technical person, right? I would want to, the end customer, the hospitals or the persons who are collecting the data should add that clause that your data can be completely anonymized and then shared for research and other purposes. And people, once it is anonymized, they should be okay to share, and that should not be a problem, is what, as a technologist, I consider. And then for someone who is taking that anonymized data, which is irreversibly anonymized, right, for research purposes, so they should not be asked to take again consent. And that will be really irritating if that is what that law is doing. But I don't think it is going that way.
But in
And
any case, for research, analysis, all of that, Mr. Sen read out a clause that you may not need consent.
yeah,
Yes.
but if it is PHI and PII, it is, even if it is for research purpose.
Okay, okay. So it's a little more nuanced than just a blanket exemption.
Yeah. It's not blanket exemption. Mr. Sen, please correct me if I'm wrong.
Can you? I didn't understand what PIL and PHI.
Personally identifiable information and patient health information. Even if for research purpose, if we collect it, if it can identify the end user, it is still consent is needed, right?
So I think that's a fantastic point. And let me read out one thing here. So one sec. So personal data, again, just to go back to the concept, the way I've understood it, if it's anonymized, it is not personal data, right? Because you can't identify the individual. Therefore, the usage of the, please see section, 16(2) with B, which says the provisions of this act shall not apply in respect of processing of personal data. So my point number one here, it is not dealing with anonymized data, but non-anonymized data from which the individual can be identified. That is the usage of the term personal data, right? Which says it shall not apply in respect of processing of personal data necessary for research, archiving, or statistical purposes if the personal data is not to be used to take any decision specific to a data principle and such processing is carried on in accordance with such standards as may be prescribed. So in my reading, even if it is non-anonymized, but the data is being collected purely for archiving, statistical, and research purposes, based on which no decision the individual has to take, then it may fall outside the purview of the act. So it's not only anonymized in my reading.
It is far more granular in that case.
Yes.
The decision part of it. Now you have to take a decision on what is that decision that you're going to take after the research.
Yeah, but in that sense, it should. I mean, it's less irritating. Just to use the phrase that it's less irritating because if you can show it's manifestly for research, then you may be able to get away from the act. That's all.
Now, being a radiologist, let me ask another question about, again, identification and de-identification. So I do a CT scan or MRI of a head and neck of a patient. And today everything is three-dimensional. And I've deleted the name of the patient. It's de-identified in that sense. But I can make a 3D surface rendering of that scan. And the face can be seen. And some AI app can actually tell you who this is. Then what happens?
I think then it is personal data because because personal data today, as I said, it is who is identifiable by or in relation to such data. So the minute the person can be identified in any means, I think one will have to take that classical conservative view in order to be prudent because
I'm shooting myself in the foot, but this point I'm sure will come up.
Yes.
And so one will have to be careful here as well, because there are apps which AI can just tell you who it is, maybe getting it right 90% of the time.
Yeah.
So
just wanted to add one more here thing to Dr.
Yes,
Mahajan's point. So this is something that I have, looked upon in the past. So in any form, gait analysis or any biomechanical analysis of a individual would require pre-existing consent in place. So anything that, even if we end up deleting the name of the individual and then going forward to process it, that would be a violation because that would not be a fiduciary act because it was not originally informed to the patient or whomsoever that we are doing with. Post confirmation, if I have been informed of the fact that your image is going to be made into a 3D hollow image for us to train our own particular model, for example. At that point in time, the irreversibility of the aggregation or the anonymization should be in such a level that it needs to compare against only other MRIs and CT scans. It will not come back to any physical trait or personally identifiable or health information to which it can match an individual. So a very crude example would be somebody with a specific gait would be at a 65 kilogram weight, and somebody with a specific gait could have a 70 kilogram weight. And there would be a massive difference in the way that a system would process that. Therefore, in my opinion over here, it would not be directly identifiable, but consent would be the bedrock on which any imaging, scanning, any tech-based healthcare operator can actually go ahead and do this.
Another thought, I'll just come to you, Ansuya. Another thought is that probably this is one problem statement where a startup can actually make a masking software where the moment you make a 3D, it'll mask the surface. Should be very easy. In fact, we'll try doing it. It should be very easy because this would be very useful then. That you would be able to mask completely. That the moment you make a 3D, it masks it. Yes, Ansuya, please go ahead.
Yeah, I just wanted to chime in on the point that you brought in. It's a very, very valid point. In fact, when we have discussions with our privacy council about specific research collaborations involving collecting data for example, for brain studies, the point that you brought in about 3D rendering and being able to identify or re-identify is something that is discussed. And I think that's a very important aspect, and we go through this with our privacy council. So from a practical implementation standpoint for us, that's something that we make sure is answered.
There's someone who's unmuted. Could you please mute your speaker? I mean, being a MRI radiologist, this is the first thing
Yeah,
that
yeah.
comes to mind. Now, let me go to the next question. This is Priya Joshi. Good morning, Mr. Sen. Going forward, will all the clinical white papers written by Indian doctors need to be redone per DPDP Act? Kindly help to understand.
I'm not really sure why white papers will have to be redone in terms of the DPDP Act. I think any kind of usage of data, uh, and again, personally identifiable data, will be relevant. Again, if this falls within the domain of research, statistical analysis, etc., it may fall outside the definition. But if any one case study is being taken up, where it's being presented, as I don't know, again, I'm imagining myself in the medical fraternity and what it could be. But if there is any one such, case study or something that is being discussed, then yes, I would imagine consent would definitely need to be taken to deal with if that data is being presented. Because otherwise, the data which is with the doctor or with the medical establishment, that I assume would already have the consent, necessary consents, including processing, usage, and going forward. But if it is being presented, yes, I think it will certainly need permissions as long as it is identifiable data.
If it's not identifiable,
then I will again imagine doesn't fall within definition of personal data.
so then, Priya, it seems that things will not change as far as writing up research papers or publications in medical journals or presentations in medical conferences about, a new tumor or something that new treatment. I don't think that is going to dramatically change from how things are today. Then we have Rohan Nagpal who says, "Good morning, everyone. Please, okay, Rohan to apna hi hai banda." Priya again saying companies like Samsung have already introduced chips inbuilt which constantly records patient data. How do they have binding to this DPDP law?
I think this is similar to the wearables discussions that we had. I think, which where they are constantly recording data. Again, the answer would be today they may not be in compliance with the law because the law is not in effect today. But by the time it's May 2027, for all such data that is being collected, I mean, first of all, awareness has to be brought to the individual that your data is being collected. Specifically, consent has to be taken with the notice as to what data is being collected, how it is being transmitted. As Shivaniji mentioned, it's going from Bluetooth and what it's being used for. So I mean, all everywhere. I think everything that collects data, background noise, I mean, people say some of the devices are listening. Whatever data is being used, which is not being used for espionage, and there is, I must say, and this is on the lighter side, there is an exception to the state taking activities in the interest of public order and safety. So if there is any snooping activity happening there, that is exempt from the DPDP Act. Apart from that, everything else will have to have a requirement of a law. Of the consent, sorry.
Then there's another, Priya. Many Indian companies tie up with global companies that process data. How should they function in India?
So again, if the data is of a data principle outside India, so that's actually maybe an interesting question. I just want to read section 17 once, just to be clear. If a data is pertaining to an individual who is residing in India, so section 3.2 becomes relevant to begin with. I think section 3.2 it says that where the data, it also applies to processing of digital personal data outside the territory of India if such processing is in connection with any activity related to offering of goods or services to data principles within the territory of India. So that's point number one. If you have an agreement with someone outside who's going to process your data, but you're the data fiduciary, and the data belongs to an individual in India, the act applies. And therefore, your agreement with the data processor outside will have to have all the requirements of safeguarding, indemnities, and so on and so forth. And you'll also have to ensure and maybe show that you have tried your level best to do the diligence to make sure that they have the technical capability to safeguard it. The other flip side is section 17. I just want to read section 17(1)(d), which says personal data of data principles not within the territory of India is processed pursuant to any contract entered into with any person outside territory of India by any person based in India, the provisions will not apply. Right? So therefore, data of data principles who are outside India, and you are doing the job within India of processing that data, that is not within the purview of the Act. So two scenarios are dealt with. Yes.
So it means, there's so much data that's available on the net, which is uploaded free, NIH, so many other. So that data can be downloaded and used for building whatever AI tools, whatever the case may be. That is permitted. Foreign data of those who reside outside India
Yes.
doesn't fall under the purview of the DPDP Act.
Correct.
Is that right?
Correct. And it says subsection 1 and 5 of 8 and section 16. So one sec. So subsection 8, 1 and subsection 5 of section 8 doesn't apply. Actually, this will require a little more study, but section 17 does exempt data of data principles which are being used by any person in India. But it does require a bit of study, frankly. Okay. But anyway, data that is freely available may not be data that you're collecting from a data principle, and therefore that may necessarily stand apart. So just if I look at section 3(b)(2), it says it shall not apply to personal data processed by an individual for personal use, which is obvious, and personal data that is made or caused to be made publicly available by the data principal or any other person who is under an obligation under law or who has it. So if you're not the person responsible and that data is physically available online and available publicly, it may not apply in the sense that you have to go and take consent of the individual who has the data.
I'm trying to understand the nuance. we get 1,000 scans from the US
Yes.
who are not of Indian citizens, and they've been done in the US, and we are using those scans, even if, say, there's a agreement and a hospital says, I'm sending you the data, kindly make a device or make a software,
Yes.
AI software. How can our DPDP Act apply to that? I mean, where's the nuance in this?
So there are two aspects that may be relevant in this case scenario. One would be whether you're the data fiduciary or a data processor. Because if you are going to be converting that data on the instructions of this entity outside, who is providing the data to you and telling you what he wants done with it, my first argument would be that we, in that case, would be acting as a data processor and not a data fiduciary. If we are not acting as a data fiduciary, that is, I have no role in the in deciding the data that is collected and what is to be done with it. I'm acting on instructions. That may be a data processor, therefore falling outside the act. Second is 17(1)(d), as I read out. It is a data of a data principle not within territory of India. My worry is 17(1) says that except subsection 5 and 8, which frankly makes no sense to me because subsection 1 of 8 simply says you shall be responsible for all the data with you. And subsection 5 essentially says you shall be responsible for safeguarding it. Now, how can one say that I will not be responsible for the grievance, for the DPO, for taking consent, etc., when it's an individual outside India, but I'll be responsible for the safety of the data? So that's why I'm saying there is a nuanced reading that's required. But on first blush, what it seems to be is that the law says for data for an individual outside the country, this act doesn't apply except your obligation to safeguard that data. It can't be lost by you. It can't be easily accessed by you because it's someone else's data, but you may not have the requirements to behave as a data fiduciary for all other obligations with respect to that data.
Okay.
As I said, we lawyers are going to have a field day.
Yeah.
Once-
Then we have Surinder again. If a device manufacturer sponsors a clinical performance evaluation of their product, manufacturer defines processing and collection of data, engages a CRO as service provider, and then actually collects the patient data as per defined protocol at a hospital, does the manufacturer become the fiduciary?
Yes, I would, because by that case scenario, he's the person who's getting the data collected. He's the person who's defining the processing and collection of data. That sentence by itself would be sufficient to constitute the manufacturer into a fiduciary, in my view.
So there would be two data fiduciaries here.
There can be
One,
several. And that's a great
yeah,
point because data fiduciary definition is a person who alone or in conjunction with any other. So there can be more than one data fiduciary in any given scenario as well.
yeah, because here, the hospital where the scan is or the treatment is being done,
Yes.
they would be fiduciary for the patient. Then they are sending it to the manufacturer who's actually authorized. The manufacturer would be the fiduciary as well.
So I think that in this scenario, unless I've misunderstood, and this may be technically more layered, but the CRO service provider who's actually collecting the patient data may only be a data processor
Right.
because he's acting on instructions alone.
So the expected timeline for full enforcement is 13th May 27.
That's correct. Unless shifted by the government.
So the hospital is providing this service like the CRO. No, the hospital is a data fiduciary because it's providing treatment or scanning to the patient. So there
Yes.
are, Surinderji, two data fiduciaries here at least.
Yes.
Then we have
Yeah, it's the government
Mr.
hospital.
Rajagopal, who asks, will the government hospitals and entities also fall under this act as data fiduciary
Yes, because there is
whenever
an
applicable?
exception provided.
So it applies equally
Yes.
to the government as well as the private.
Yes.
See, there is this GE Healthcare based out of Bangalore, Philips and Siemens Healthineers. The top three MNCs are global companies. Here they are functioning under the DPDP Act based in India. Do they really use the cloud? If yes, is it limited to using the data? And what is the limitation and governance of that data? Can you understand?
Yes, this is probably a question to the Anushya, Shivani, and Raju, because this is, I think, their practice that there is this question dealing with that.
I think what is not clear is what is the context under which that is being asked. Is it in terms of a clinical study, or is it for product development? What
No,
is the
I
context?
think this may
Yeah.
be in the context of co-development,
Mhm.
of software, where guys here are working in the day, and since it's night in the US, they are working there. So this co-development happening. So there, if it's de-identified data, probably, once you've taken consent in the beginning, that's all that may be necessary.
Yes, and there is also the GDPR Act that that we are all already compliant to, and that's something that's been established through the years.
Right. We have
Yeah.
7 minutes left, so let me rush through. Um, Dr. Namita, where did I lose? Yeah. Again, are you sharing the presentation? Because she can't see it. Yes, we'll be sharing it. Uh, Many big conglomerates who operate based out of US, UK centers in Bangalore, does that make them free from DPDP Act? No, it doesn't make them free from, at least that's our understanding. And their Indian counterparts are liable for legal responsibility, or would the parent company take the ownership? Would the parent company also be liable if placed outside India?
Yes, because in terms of 3.2, if the data pertains to data principles within India, then the Act applies, even if it is processed outside India.
Okay.
So depends on, who's done the breach and who's the fiduciary.
Yeah.
Yeah, I like the next question. Can we define less than 5 years or 10 years? I would love to, but I don't think we can define it. The Act doesn't define the period for the legacy data.
But then legacy data, if you don't have, or if you de-identified it, it seems you may be clear,
Yes,
because right now you don't need to take permission for de-identification.
currently you don't. Yes, I
Yeah.
mean it's governed by your consent norms at the time of then taking. But yes,
So if a data processor, data fiduciary to a hospital, vendor is changed to another, what are the aspects to be kept in mind to have a smooth transition? Do we need to obtain the personal data consent again with the new vendor?
so, I mean, one would imagine that you won't need a consent with the vendor. The vendor will be a data processor. So, therefore, he will have the contractual obligation with the fiduciary. The smooth transition between one processor to another essentially is a contractual regime where you'll have to ensure that the liabilities are back to back, and you'll have to ensure that the processor undertakes and clearly transfers all data, maybe just deletes all data or transfers whatever processes have been done to the new processor, and then has no record of the same, and he deletes it because you can't have an unauthorized access to that data. However, the important question is whether your consent form specifies who the data will go to. If in that scenario where you've taken a specific consent and you've given notice as to where the data is going to go and what kind of processing will happen, if that changes, then I would imagine you need a consent again, reading the law as conservatively as possible, given that consent has to be absolutely specific.
Okay. So if we say vendor
Yes.
rather than putting the name of the vendor,
Yeah.
then probably it would be
Yes.
fine and you could change one vendor to another
Correct.
without having to go back.
Correct. I would imagine one shouldn't even go in that direction. One should only specify how it will be processed. Who it will process may not be as relevant to the principle. I think Mr. Ramprasad has something to say, Raju or something.
Yeah, I just wanted to add on to what Mr. Sen was saying. So ideally, we should not be going down that pathway to see whether liability transfers, because in a very well-made, concise, granular consent statement, it will very clearly call out the fact that we will be transferring it to our partners, vendors, and third
Sure.
parties. And getting into an itemized list might not be practical because these are organizational commercial calls that are made in real time. And going back and obtaining, retrospective consent is not going to be applicable over there. So ideally, it needs to just move forward to the new vendor and business as usual continues. And on the back end, the patient or the customer does not even know this occurred. Essentially, for them, the flow should be the same.
Let me ask one quick question, which I asked last time as well. Is all this, complexity there in, say, the US or Japan or France or England as far as patient consent? Do they go back and seek reconsent? Do they seek consent for deletion of data? Is that where this has come from? If yes, then we are no worse off, and they've been doing it for years, so we should be able to do it as well. But if no, and this is more nuanced or more aggressively worded, then probably we should look at those countries where privacy of data is extremely important.
No, definitely. So they do go back. Sorry,
No,
you
no,
want
go
to
ahead,
take
go
that?
ahead.
No,
No,
no.
go
Yeah,
ahead.
they definitely do go back for consent if there is going to be deletion, but for not other purposes, because this effectively is something that's covered under the CCPA or the HIPAA or the GDPR in each of these countries. And these are much more mature than what we have currently in India as a first step into what we are stepping into, a privacy protection and privacy regulating regime that we have. And to answer your question, something that I've also like heard in my current organization is that hey, this HCP says that they are already preoccupied, they don't want to go back and do this and do that. But the other markets that we're speaking about in other foreign countries, in Japan, in China, in the US, in Europe, they definitely have a much more mature system where, if not for a majority of it, but at least 40% of the requirement is pre-digitized or is already in a digital workflow format. So obtaining consent at that point in time or changing the narrative at that point in time is not the main cause of concern because there is pre-existing consent.
Also, most
And
of these
any
countries,
erasure would definitely require standalone consent,
sure.
to be honest with
And
you. Yeah.
most of these countries have, the large part of the population covered by health insurance. So it may be, health insurance which actually kind of gives you a blanket permission for one thing or the other. I don't know if that's actually the case, but it could be.
No, I think also, Dr. Majan, as we go forward, see, right now, as I've said before in the previous webinars, as lawyers, we are trained to be paranoid and to look at things in the worst color possible in order to be able to advise and to be able to prevent liability. But I do think that once it comes down to a discussion, what is the reasonable interpretation of these rules and consent will be looked at in the global scenario, because here GDPR, etc., some of the definitions are very similar to what has been used in the DPDP Act. So therefore, how globally it's understood in terms of best practices will certainly weigh in with the government as well as with the courts and the board. I assume so.
We have Alex asking, can I use a server which I bought for another purpose to collect medtech data, to monitor trend of disease or whatever the case may be?
Yes, again, I don't see any reason why that shouldn't be the case. We have to remind ourselves that the DPDP Act is essentially with the individual, and the individually being told and having been told, consenting specifically to it, and your data being free and safe. and to unauthorized, to not allow any unauthorized access or usage. That's all that there is to it.
So you can save your personal data. You can use it for whatever on the same server. You can save this data as well.
Yes, as long as the access,
It's
etc. is
safe.
also
Yes,
correct.
yes. Then we have Mohan Ramakrishnam. Do we need to look at hardware data same as cloud data from a compliance perspective, specifically from an accountability point?
Again, if it's data which is in digital form, data pertaining to an individual, I mean, by hardware data, if we are not talking about hard copies and physical data, then yes, it's, I mean, the law is not distinguishing between where the data is coming from or where it is stored. It only concerns itself with the fact that it's personal data for which some amount of processing is happening, which is not research.
Okay, after deleting, Priya has been very active. After deleting the personal data, is there an Indian law to store this unidentifiable data in cloud? Is there any clarity under DPDP Act? I think we spoke about de-identified
Yeah.
data, and probably that'll fall outside the purview, provided you have taken consent for
Yes.
de-identification, which would fall under processing of data.
Correct. I would imagine so, yes.
Mr. Rajagopal, so all medical device companies should appoint a DPO. I think every household would need one.
Yes. No, that's not a bad question, and I'll tell you why. Because this is something I've discovered in recent times, that there is no obligation on. So there is no stated obligation which says that every data fiduciary must have a DPO, which is there in the case of a significant data fiduciary. But Section 6.3 mentions that in the event of a deep crisis, in the event of a grievance, every fiduciary must be able to say who's my data protection officer and who's my grievance redressal officer. Sections 8, subsection 9 and 10, I discovered, also say the data fiduciary shall publish. The word is shall, which is therefore a mandate. It says shall publish in such manner as may be prescribed the business contact information of a data protection officer, if applicable, or a person who's able to answer on behalf of the data fiduciary the questions raised. So therefore, it is being nebulous as to whether a data fiduciary is required to appoint a data protection officer, but certainly someone, because even that language seems to say it shall appoint a DPO or any other person that it authorizes. And lastly, Rule 9 says every data fiduciary shall prominently publish on its website so and so, and the information of a data protection officer, which is slightly in conflict with Rule subsection 8, 9 as we read, because it says if applicable. But then Rule 9 says every data fiduciary shall publish information on a data protection officer, which in my reading would therefore mean everyone has to have a DPO.
Okay. We are 5 minutes over time. Last 5 minutes, I'll take the questions that are there. Ishan Agarwal, anonymization is irreversible. Pseudo anonymization is reversible. The understanding is anonymization will not require consent. Can someone confirm this? I think we will need consent in the beginning,
Yes.
or at the time if we want to anonymize, if we haven't got the consent earlier. So consent is necessary.
Sure.
Right? Ms. Sen, I'm taking your thunder away. Because you now, made us much wiser.
Dr. Majan, the problem is you can easily do what I am doing. I can't do what you're doing.
No, but AI is going to be doing what I'm doing, which is reading scans.
I think there's a question specific to GE, Philip, and Siemens.
G. Philip Siemens specific question. Do they take consent as of today to conduct clinical trials in India and Africa? In India, certainly. In
Very
India,
much.
certainly.
Very
Yeah,
much
yeah,
so. Yes.
I'm on the NABH, trials, and without consent, you can't do anything.
Correct.
Yeah. How should a medical device company be classified when its surgical navigation system processes patient CT MRI data solely to provide intraoperative guidance where the hospital determines the purpose and use of such data. Would the company be considered a data fiduciary or a data processor? This is Amit Rangta who's asked this question, and it's a very relevant question.
Provide interpretive guidance when the hospital. I think I don't know. Actually, this is an interesting one because if there is any amount of, uh, I don't know, I mean, supervision, any amount of discussion, decision making in terms of what processing will apply, what data will be collected, I would imagine both of them can qualify as data fiduciaries. If they are acting, if the company is acting purely as a service provider to the hospital, maybe not. But these are
See,
the
this is like,
cases.
say, we talk about one of these robotic surgery devices where you feed in the CT, MR, or whatever data, and based on that, you can tell the robot where to go operate and all that. I think they would be processors
There
only.
will be
Yeah,
process, and that's
There's
yeah.
no
that is
way
certain.
that they can become fiduciaries.
Correct.
Amit, I hope that clarifies something. Uh, Hospital would also, okay, that we've gone. Okay, Ajay Kumar, want to know if DPDP Act is applicable on data collected during demonstration on ultrasound as a pre-sale or post-sales activities. So,
Yes, I don't. I think certainly because it doesn't matter what it was used for. I mean, you have to take the consent for whatever the purposes that the data is being collected and then thereafter presented.
but suppose it is just demonstrated live and not stored on the device, then would the DPDP Act apply?
Yes, because even for the demonstration live, I think it will fall within the definition of processing. So a consent will be limited to that. And it will be limited to saying, I take your consent that I will be demonstrating it, and then thereafter I am deleting it. So the consent will be for both. The minute the data has entered your system where you have collected it, you're taking consent for A, collection, B, demonstration, C, deletion. So I would still feel consent is certainly required. You would be make very clear that I'm not saving it, and therefore the rest of the information, rest of the compliance, I'm sorry, would not apply to me.
So, Priya, finally saying my last question. Vendor, does it mean GE India and GE US or Siemens India and Siemens Healthineers? Uh, who is the vendor? Is the vendor also GE US when GE India is selling a machine?
I think it depends on the legal manufacturer of that particular device.
But here it is
Yeah,
all
it could
about
be.
data storage. It's not so much about equipment itself. So whosoever stores the data on a
Yeah.
device is the data fiduciary. At least that's my understanding. Mr. Sen?
Correct. Yeah, I agree. I agree. Whoever is storing the data, whoever is deciding the data that is relevant, whoever is deciding the treatment for the data would become the data fiduciary, I believe. And they can be more than one, let's be clear. They can be more than
And
one.
again, this is Priya further, writes for software as a solution.
I don't know what that means. I'm sorry.
That is, using software like AI
Yes.
is a software which you use, where it may go to cloud somewhere and come back and all of that. But I think that would probably qualify more as processing rather than
Possible.
storage.
Yes.
So I think 2 hours and 11 minutes we've been on. It's been very interesting. We've learnt a lot, and hopefully we still have about 100 people who have stuck even beyond the time. And so thank you all very much, especially Tisham, Sivani, Ram Prakash had to drop off, Ansuya, and Fiki for having done this. You brought this, I think, into the mainstream of the thought process of healthcare providers, and also alarmed a lot of us as to the very steep duties, responsibilities that would be thrust on us. And it is incumbent upon us as the healthcare industry to actually sit together and try to simplify acts. I'm sure the government doesn't want, very complicated things. It's really concerned about data privacy, personal data privacy. And towards that, if we can actually bring in systems which make it simple rather than complex, and the systems which are robust and which keep the patient, in our case, at the center of the whole universe of data privacy, I think we would be doing both the patient, the government, the legal fraternity, and us. Maybe not the legal fraternity, they would want it as complicated as possible. But to all of us as the healthcare industry, we would be doing a favor. And I would request FICCI leadership to take on this role of simplification of the whole process, so that those who are compliant are able to remain compliant and not have to fret about not being able to do that. So thank you very much. Over to you, Rohan. Take it from here. Thank you.
Thank you so much, sir, for your time. So I'll just take another minute and we thank all the esteemed speakers who had joined us for an impactful session today, and to the participants for staying us till the end of time. So on behalf of FICCI, I would like to thank all of you, and we look forward to continuing this support and dialogue while there is support from the sector in navigating and evolving the regulatory landscape that we live into. So thank you, everyone, and have a very good day. We look
And
forward to
special
further
thanks to
sessions in future.
Shilpa
Indeed, sir.
for having put it all together. Thank you very much. Bye. Have a great lunch.
Thank you. Bye.
Thank
you
you.
all.
Bye.